We decided to discuss riparian rights using an example of a fisherman that is fishing very close to a dock. We also discussed some of the exceptions to riparian rights that can be seen right now with the drought in California.
One morning, Sam became angry because a fisherman was fishing on the lake in front of his property. He yelled,
Get off my property!
but the fisherman just ignored him and kept casting. Sam didn't understand why the fisherman didn't listen and decided to ask his friend about his water rights.
Marley, why didn't the fisherman move when I asked him to?
The fisherman is allowed to fish in front of your property because of riparian water rights.
What is that?
Well, riparian water rights are a system for allocating water among those who possess land along its path. Under riparian law, water is a wandering thing like the air, sunlight, or wildlife. It is not owned by anyone, rather, part of land over which it falls from the sky or travels along the surface.
So the lake space in front of my house doesn't really belong to just me?
No, in fact, the water is split among all of those who own property on the lake.
What do these rights include?
They include the right to swim, boat, fish, drink the water, use it as irrigation, or to put in a dock or lift.
So I can use all of the water in the lake, even though others live along its border as well?
The law states that riparian owners are permitted to make reasonable use of this water as long as it does not unreasonably interfere with the reasonable use of others with riparian rights.
Do riparian rights only count for certain bodies of water?
No, riparian rights are present for all bodies of water that have people living along its border. This includes streams, lakes, ponds, and even oceans.
Do riparian rights exist in all countries or just the U.S.?
Most countries regard the water as a state property, where in the U.S., the public aspect of water is distinguished by riparian rights, which are considered to be private property rights and are protected against governmental seizure by the U.S. Constitution.
So when were these rights created?
The English water law first adopted in the U.S. was premised on the natural flow doctrine. This said that any riparian owner had the right to a natural water flow of unlimited quantity. Then, by the mid-19th century, almost all American states had stopped using this doctrine and adopted a second doctrine, which called for reasonable use instead of unlimited.
Are riparian rights the only water rights in the U.S.?
No, there is also the prior appropriation doctrine. This doctrine states that water rights are determined by the priority of beneficial use. Basically, it rests on a first-come, first-served basis. The first person to use the water or divert water for a beneficial purpose can obtain individual rights to the water.
Now that I know all about riparian rights, I should probably apologize to that innocent fisherman. Thanks, Marley.
No problem.
Sorry!
There can be exceptions to these rights. For example, the current situation in California. The water usage has been limited due to a severe drought.
Farmers have been asked to either reduce water diversions under their riparian rights by 25% or to not use 25% of their farmland.
Water right holders throughout the state have been warned that there is a very likely chance of further curtailment this year because of the continued unprecedented drought conditions.
Residents of the Sacramento and the San Joaquin River watersheds will have to be curtailed for the second year in a row.
And last year, hundreds of thousands of acres of farmland were fallowed.
These water rights are the most secure of all the state's water rights and are only curtailed when the natural flow of water is not sufficient to serve a reasonable purpose to all riparian right holders.
This program could serve as a template for all states that experience droughts in the future.